overseas. The statistics are alarming, with more than 770 Australian registered child sex offenders travelling overseas in 2016. Alarmingly, a third of them violated an obligation to notify their police of their intention to travel. Currently, under existing laws, a failure to report intended overseas travel or to comply with other obligations can result in up to 2 years' imprisonment. However, the penalties handed down by the courts are generally warnings or small fines, which provide little incentive to comply. This is completely unacceptable and clearly ineffective. These offenders have a high propensity to reoffend in countries where they are not monitored and where child sexual exploitation is rampant. Registered child sex offenders are subject to reporting obligations in Australia specifically because of their ongoing risk to children. This bill will address current deficiencies and will prevent Australian registered child sex offenders with reporting obligations with the measures I've outlined. Once their reporting obligations have concluded, offenders will be able to apply for a passport in the usual way. And while the Nick Xenophon team supports the bill, we are concerned about the unintended consequences of the measures fuelling cyber sex trafficking, which is why I will be moving amendments to the Criminal Code to tighten existing sections of the Code to prevent these unintended consequences emerging. And I'll move those amendments during the committee stage, Madam Deputy President.
Thank you, Senator Kakoschke-Moore. Yes, Minister.
Thank you very much, Madam Deputy President, and I would like to thank all senators for their contribution to this debate on this bill, which will combat the sexual exploitation of vulnerable children overseas by Australian child sex offenders. And I would like to particularly commend Senator Hinch for his dedicated contribution to this debate over many years. I also thank the senators from the Nick Xenophon team for their proposed amendments to the bill. We appreciate your shared concerns in ensuring that vulnerable children are protected from the dangers posed by child sex offenders. However, the government would like to consider those proposed amendments in further detail to ensure that they function with the existing provisions, and will progress this as part of the package of child sex offender reforms being progressed for the spring sittings. This bill reflects the seriousness with which the government is addressing child sex tourism. These tough new measures send a strong message to child sex offenders that they cannot use overseas travel to sexually exploit and abuse children. Such abhorrent crimes will not be tolerated. The risk posed to vulnerable children overseas by Australian child sex offenders is utterly and completely unacceptable. There is currently no effective mechanism to stop Australian child sex offenders from travelling overseas to countries with weaker law enforcement frameworks where their activities are not monitored. The measures are intended to capture all Australian registered child sex offenders with current reporting obligations. When an offender's reporting obligations end, they can apply for a passport as usual. This is necessary and appropriate because registered child sex offenders are subject to reporting obligations in Australia, specifically because of their ongoing risk to children. For these measures to be effective in stopping child sex offenders from travelling overseas to commit horrific acts against children, it is essential that the passport decisions are mandatory and not subject to merits review following a competent authority request for passport denial. Unless these tough new laws are introduced, Australian child sex offenders will continue to travel overseas and be in a position to commit those offences. These laws will make Australia a world leader in protecting vulnerable children from child sex tourism, and I urge senators to support this legislation as a matter of urgency.
Thank you, Minister. The question is that the bill be now read a second time. Those of that opinion say aye. Those against say no. I think the ayes have it. I call the clerk.
Passports Legislation Amendment Overseas Travel by Child Sex Offenders Bill 2017.
Is it the wish of the committee that the bill be taken as a whole? There being no objection, it is so ordered. The question is that the bill stand as printed. Senator Kakoschke-Moore.
Thank you, Madam Chair. I seek leave to move the amendments on sheet 8158, standing in my name, as a whole.
Is leave granted? There being no objection, leave is granted. So Senator Kakoschke-Moore.
Thank you, Madam Chair. In Australian households and workplaces, paedophiles are paying to direct live sexual abuse of children located anywhere in the world. I'll let that sink in for a moment. Australians are paying for children in developing countries such as the Philippines to be sexually and physically abused for their gratification while they sit in their homes, watching and directing the abuse. Sadly, this despicable act isn't being committed by just a few. The crime is known as cyber sex trafficking, a form of trafficking that is transnational and involves offenders in Australia who commission the abuse of children in developing countries on a pay-per-view basis. Cyber sex trafficking is much more common than people may think. According to the International Justice Mission, the annual number of tips to the National Centre for Missing and Exploited Children rose from 4,560 in 1998 to 76,584 in 2006. In 2015, that figure ballooned to 4.4 million. Australian law enforcement agencies are well aware of the prevalence of this crime and are doing what they can to combat it. They face significant hurdles given this crime is transnational and they must work with international authorities and laws. In a Sydney Morning Herald article of the 3rd of June 2017 by Lindsay Murdoch, the unintended consequence of this bill before us was highlighted in a piece titled "Children as Young as 2 Rescued from Philippine Cyber Sex Abuse Dens." The article quotes John Rouse, head of Task Force Argos, who said more cases of child cyber sex are being uncovered because of the increasing capabilities of law enforcement agencies, including in tracing financial transactions. "We are detecting it more because we are looking for it more," he said, adding that Australians have been known to be involved in the online sexual exploitation of children for almost a decade. Asked whether the involvement of Australians was growing, Detective Inspector Rouse said, "It is already quite an established market." The International Justice Mission, or IJM, helped rescue 201 children who were forced to participate in online sexual exploitation between 2011 and May 2017. More than half of the victims were under 12 and 70% involved parents, relatives or close family friends of the victims. I pause again to let that sink in. Parents are sexually exploiting their children for the gratification of Australians. The article goes on to say that Evelyn Pingle, IGM's Director of Communications in the Philippines, said the alarm needs to be sounded that online sexual exploitation of children has become an epidemic in the Philippines. She said, "We need the police to continue rescuing these children. We need the prosecutions to continue convicting more sex criminals," she said. IGM's National Director called for law enforcement agencies to be given more resources to fight this horrific crime against children. One such resource is the ability of Australian law to capture this type of behaviour so that it can be successfully prosecuted and offenders properly penalised. Not only is IJM carrying out life-saving work on the ground in Southeast Asia, but IJM Director of Corporate and Legal, Kimberly Randall, has also identified the gap in the law which exists here. Despite the number of instances of cyber sex trafficking in Australia, the Criminal Code does not adequately address the specific nature of this crime. Prosecutions for cyber sex trafficking occur under sections 474.26, 474.27, 272.8 and 272.9 of the Commonwealth Criminal Code, Act 1995. According to IJM, sentences for these offences have tended to be significantly lower than hands-on offences and do not currently reflect the case that the sexual exploitation of a victim is being commissioned in real time. The offences of sexual intercourse or activity with a child outside Australia were intended to capture Australians travelling overseas and engaging in sexual intercourse in person. But in the case of cyber sex trafficking, the physical abuse inflicted on children occurs overseas but is commissioned, directed, paid for by a perpetrator in Australia. That is why I will move an amendment to these sections of the Code which make it abundantly clear that a person committing an offence under these sections does so when they are in the presence of the child by means of communication that allows the person to see or hear the child. In other words, when they are committing the offence virtually, which should make them no less culpable. It is important to note that in 2 recent cases of cyber sex trafficking, the defendants pleaded guilty. Had they pleaded not guilty and the Criminal Code in its current form been tested in its ability to capture their online pay-per-view crimes, then they may have gotten away with their dreadful acts. In the much publicised case of Brian Beattie, it has been reported that he was charged with cyber sex trafficking. But as this does not exist, what he did plead guilty to was 21 counts of causing a child under 16 to have sexual intercourse outside Australia in the presence of himself, as well as other charges. The offences occurred between 2012 and 2014 and involved him paying amounts ranging from $12 to $540 to watch 17 children being sexually assaulted in the Philippines via Skype. These children were between the ages of 8 and 15. He also gave instructions on the type of abuse he wanted to see. Beattie was sentenced in March 2017 to a maximum of 10 years imprisonment, but he will be eligible for parole in February 2021. Carl Dawson pleaded guilty to offences of procuring a child to engage in sexual activity outside Australia, as well as child abuse material offences. He paid approximately $60 to view, to watch the abuse of children in the Philippines via Skype. His victims were girls aged about 6, 10 and 12, and a boy who was about 8. He recorded the sessions to view at a later date and possibly to share. His defence counsel said he had an addiction to child sexual abuse material. The AFP who arrested Dawson examined his computer and were able to trace the location from where the live streaming was taking place and provided the information to police in the Philippines. IJM assisted in the Philippines in arranging a sting operation where the offender was captured. The offender was the aunt of some of the victims. The total sentence was 5 years of imprisonment with a 2-year non-parole period. In another recent case, Queenslander Stephen James Sheriff started sending money to the mother of 2 girls, the youngest aged 10, residing in the Philippines. The mother sent sexually explicit images to Sheriff, and he was convicted of soliciting and accessing child exploitative material. He was sentenced to 3 years imprisonment, but was ordered to be released forthwith upon paying a $500 fine and being of good behaviour for 3 years. One has to wonder, how is that a deterrent? I've been told of cases involving babies, multiple children present at one time who are forced to abuse each other, and other situations that can only be considered to be torture. It is for this reason that I will move through my amendment to expand the types of aggravating factors to section 272.10. The new factors that will be considered aggravating factors include where the child is or reasonably appears to be under 10 years of age. This is designed to capture offences committed against very young children, such as those who are 3 or 4, quite clearly under the age of 10, because it recognises that it may be difficult for law enforcement agencies to obtain birth certificates to confirm the exact age of a victim. The aggravated offences will also include where more than one person is watching the abuse being committed against the child. This recognises that often paedophile networks are involved in the abuse of children. The aggravating factors will also include where an act of torture, cruelty or degrading treatment is done to the child while the underlying offence is being committed. This is necessary because I've heard of cases such as those involving babies having hot wax stripped on them in the course of the offence. Where a person pays for a fee or reward for the abuse to be perpetrated against a child, this will also be considered an aggravating factor. It recognises that not all abuse against a child is paid for, but this amendment does recognise that where a fee or reward is paid, profit is essentially being derived as a result of a child being abused. I will also move amendments which relate to the obligation of internet service providers and content hosts to report to the AFP if they become aware that the service provided can be used to access child exploitation material and pornography. Currently, the maximum penalty for this offence is equivalent to $18,000, and as it currently stands, the offence does not specify particular information required to be reported, such as IP addresses or personal details of the subscriber. Accordingly, the proposed amendments to sections 424.25 include the specific information to be provided to the AFP and an increase in the penalty units for non-compliance with their request. It is the case that cybersex criminals are utilising the infrastructure of telcos to commit their crimes. I believe it is therefore incumbent, a social duty even, for those telcos to ensure that they do everything in their power to assist the AFP in tracking, identifying and building a case through the online footprint captured by the ISPs against people using their service to offend. The amendments will seek clarity for ISPs about the type of information they need to provide and for avoidance of any doubt about how vital the provision of this information to the AFP is, the penalty for non-compliance is increased. There is no excuse for allowing this activity to go on under our noses. Our law enforcement agencies should be armed with everything they need to do their job without the hardship of a criminal code that hasn't kept up with the online environment or ISPs who may not see this as a priority. In conclusion, my amendments plug a gap in the Commonwealth Criminal Code expected to be exploited even further once passports of registered sex offenders are stripped. While the government's bill to stop registered child sex offenders from travelling overseas to commit despicable crimes is supported by the NXT, the unintended consequences of the increase of exploitation crimes being committed from Australian lounge rooms instead, as I've just described, should be dealt with now. The fact the abuse is happening virtually should be no barrier to a predator being charged and prosecuted, yet the law as it stands does not make it clear that a person need only be in the virtual presence of a child. The crime might be virtual, but the children are being sexually abused in the real world. And in our world, as lawmakers, I believe it is our duty to ensure that Australian laws adequately protect children, no matter where in the world they live. Thank you, and I commend the amendments to the Senate.
Thank you, Senator.